right, good afternoon, everyone. I'm Judge Corey Amanda Cotham. We're here for the afternoon session of First Appearance Court. We will begin with our first appearance docket, and then we will go to the hearing docket after that. I do have one case to address out of turn, and that is for Mr. Lauren Brown. Mr. Dutko is present in the courtroom. I do have a handwritten finding sheet that the clerk has prepared, as well as a copy of the warrant and probable cause affidavit, but I don't have a booking sheet for Mr. Brown. Yes.
Mr. Dutko and I have discussed this. It might be a moot issue right now.
All right.
Judge,
He's approaching, Judge.
this is
Oh, you do have him.
this is somewhat of a fluid issue. It's evolving. The paperwork is appearing as we're speaking.
Yes.
I've talked to Mr. Linder, and our request is if the court could see fit to reset this for tomorrow at 1 o'clock, hopefully we'll all be more prepared to address the issues. And in the interim, I will talk to the prosecutors that will actually be handling the case.
Yes. All right, Mr. Linder, do you have any objection to that?
Obviously not considering that without Mr. Dutko assisting in us getting the warrants, we were gonna have to reset it anyway, so.
Okay. All right, so then, yes, Mr. Dutko.
I apologize. I did want Mr. Brown, though, to know that his wife and family members and friends are here in support, and they likewise, either them or others, will be present tomorrow. So we're moving in the right direction.
So am I to anticipate everyone observing or speaking tomorrow?
Mostly observing. I don't know that there'll be a lot of need for any testimony. I'm trying to work that out with the prosecutors.
I think there's plenty of that in the affidavit. All right, so Mr. Brown, since you are here, I just want to let you know, as you probably just heard, your attorney, Mr. Dutko, is present in the room, as well as some of your friends and family. Based on the information that I've been provided, we're going to reset this hearing to tomorrow morning so that we can fully address all of the issues that need to be discussed. Yes, Mr.
Could
Dutko?
we do it for the afternoon? That's what I had discussed.
Oh, the afternoon?
I think it'll be less chaotic and maybe.
That's fine with me if that works for everyone else.
Yes.
All right, so Mr. Brown's case will be placed on tomorrow's afternoon docket, so it'll be at 1 o'clock. And if everyone is ready, then we can address it first thing tomorrow afternoon.
Thank you for your
All right,
patience, Your Honor.
thank you. Thank you, gentlemen. I will give that to you to hold for tomorrow. All right, thank you. Okay, let me go to Mr. Romero and Mr. Miller. Is there anyone that the jails have requested to be called out of turn?
The jails? No, Judge.
Okay. All right, I do have is Mr. Plant still here, or did he leave? Oh, here he is. Okay, I have Mr. Plant present for some of the municipal ordinance cases. If we have them in the room, then I will go ahead and address their cases. On page 4 is Tony Ehrlich.
Mr. Ehrlich is here.
Thank
Come on
you.
up, Mr. Ehrlich.
Good afternoon, Mr. Ehrlich.
Yes, ma'am.
Mr. Ehrlich, you're before the court this afternoon on 2 misdemeanor capiases. These relate to municipal ordinance violations that are trespassing and possession of paraphernalia. I find probable cause. I do have your attorney, Mr. Plant, present here in the courtroom with me. And Mr. Plant, what are we doing in Mr. Ehrlich's case?
Thank you, Judge. Sir, your offer is adjudication time served for the
All right.
trespass and the paraphernalia.
Okay, so Mr. Ehrlich, if you want to resolve these matters today, the city's offer to you would be an adjudication, time served. There would also be a no return order with regard to the trespass charge. Do you understand that?
Yes, ma'am.
All right, do you wish to accept that offer?
Yes, ma'am.
Okay, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
All right, you can put your hand down. And Mr. Ehrlich, do you understand everything we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak to your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
Do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
And what plea do you wish to enter, guilty or no contest?
No contest, ma'am.
All right, Mr. Ehrlich, I accept your plea and find that it is freely and voluntarily given. So once again, your sentence will be an adjudication, time served, and there is a no return order with regard to the trespass charge. And you understand that?
Yes, ma'am.
All right, thank you very much, Mr. Ehrlich. Good luck to you.
Look,
Thank
sir.
you.
Next, on page 5, I have Philip Wackenheim.
It's coming up, Your Honor.
Thank you. Good afternoon, Mr. Wackenheim. You're before the court on a misdemeanor capias. This is a municipal ordinance violation for alcoholic beverage violation. I find probable cause. And Mr. Plant, what are we doing in Mr. Wackenheim's
Judge,
case?
his offer is adjudication time served.
Mr. Wackenheim, if you want to resolve your case today, the city's offer to you is an adjudication time served. Do you understand that?
Yes, ma'am.
Do you wish to accept that offer?
Yes, ma'am.
Okay, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you, and now you can put your hand down. Do you understand everything we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for a mental or emotional illness?
No.
Do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
And what plea do you wish to enter, sir? Guilty or no contest?
No contest.
All right, I accept your plea and find that it's freely and voluntarily given. Your sentence will be an adjudication, time served. Good luck to you.
Thank
Look,
you.
sir.
You're welcome. On page 6, I have Vernon Coleman. Good afternoon, Mr. Coleman.
How you doing, ma'am?
I am well. Mr. Coleman, you are before the court this afternoon on 3 municipal ordinance violations. These are charges for open container, possession of drug paraphernalia, and trespass after warning. I find probable cause, and I have your attorney, Mr. Plant, present with me in the courtroom. Mr. Plant, what are we doing in Mr. Coleman's case?
Your Honor, his offer is our adjudication time served on all counts. The trespass, no? The trespass is no return,
All right.
if the court will accept that.
Mr. Coleman, do you understand that offer?
Yes, ma'am.
Do you wish to accept that?
Yes, ma'am.
All right, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
All right, now you can put your hand down. And Mr. Coleman, do you understand everything we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am. No, ma'am.
Do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
All right, and what plea do you wish to enter, guilty or no contest?
No contest, ma'am.
All right, Mr. Coleman, I accept your plea and find that it's freely and voluntarily given. Your sentence will be an adjudication, time served, and there will be a no return order with regard to the trespass charge. Do you understand that?
Yes, ma'am.
All right, thank
Yes,
you.
ma'am.
Good luck, sir.
Thank you. Thank you.
On page 6, Renee De La Rosa.
He's the first, Judge.
Thank you.
Good afternoon.
All right, good afternoon, Mr. De La Rosa. You are before the court this afternoon on 2 misdemeanor capiases. These are municipal ordinance violations for trespassing and soliciting. I find probable cause. And Mr. Plant, what are we doing with Mr. De La Rosa's case?
Your Honor, his offers are adjudication time served with no return on the trespass.
All right, Mr. De La Rosa, do you understand that offer?
Absolutely, ma'am. Yes, ma'am.
Do you wish to accept that offer?
Yes, ma'am.
All right, will you please raise your right hand? Do you swear or affirm to tell the truth? Okay,
Yes, ma'am.
thank you, and you can put your hand down.
But now you can put down.
It's okay, the intent is there. And Mr. De La Rosa, do you understand everything we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, I'm not.
Do you need any more time to speak with your attorney?
Yes, ma'am. No, I do not.
Okay. Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes, I do.
Have you ever been treated for mental or emotional illness?
No, I have not.
Do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
Yes, I do.
And Mr. De La Rosa, what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea and find that it's freely and voluntarily given. Your sentence will be an adjudication, time served, and remember there's going to be the no return order with regard to the trespass charge, and you understand that?
Yes, ma'am.
All right, good luck to you, sir.
It's done already.
All right, and Mr. Plant, are those the only cases I have for you?
There's a second look, Robin Simmons,
Let me take a look.
page 2 of the second look docket.
Okay,
She is at
Paul Ryan?
Paul Ryan.
All right, right?
All right, good afternoon, Ms. Simmons.
Hi, Your Honor.
And let me just have a look here. Ms. Simmons, her bond is set at $25. All right. And I believe when Ms. Simmons was in front of me the other day, and Ms. Carr was here, I told her I would not accept a plea offer because Ms. Simmons was in front of me last week for the same charge.
Yes, I remember it.
All
See
right.
you in court, ma'am.
All right. So, Ms. Simmons, I'm going to leave the bond as is, and you'll be seeing your division judge shortly. Good luck to you, ma'am.
Good luck, ma'am. Thank you, Judge. That's it.
Thank you, Mr. Plant. All right. I have one other case that's on the hearing docket to address because he has family present. On page 2 of our felony docket, Arlington Salter.
He's
His-
approaching Judge here at Maine.
Thank you. His
And
wife-
Judge, he's also on page 2 of the misdemeanor docket.
Okay.
His wife and mother-in-law are here to speak on his behalf.
Thank you.
I discussed with Mr. Linder the possibility of him resolving the misdemeanor, and we're going to ask the court to give him back his original bond
Okay.
on the felony so that he can bond out.
What was the original bond?
It's a possession of MDMA, so I assume it was $1,000. That's usually the convenience bond. He lives in New York.
Okay.
And so he's unable to comply with the Elmo requirement of pretrial release. If the court's not interested in that, the family is going to be able to post the bond for him.
Okay. All right.
Just need a moment to look up his, I didn't know that they were gonna be asking to have the bond set back, so I'll
Go
look
ahead.
up his driving record.
What facility is he at?
Is it the main?
Is that Maine? Okay. All right. Good afternoon, Mr. Salter.
Good afternoon.
Okay, so this is a second look on both cases. And I'm just giving Mr. Linder a moment to check on his information and see what he's got for me.
Looks like this occurred mid-April of last year. Because of that, this would be his third, but it would not result in a 10-day mandatory jail sentence. He offered being adjudication time served, but he has to be aware, if he comes down to South Florida, or anywhere in the state of Florida, drives with a suspended license, he's facing getting arrested on a felony offense and other ramifications.
Be advised.
Thank you.
It looks like this will be his second within 5 years.
Okay.
Well, it already is, but no, it would be an habitual revocation.
Judge, I did explain it to him, and he wishes to resolve the driving offense, Judge.
Okay. All right. So with regard to the misdemeanor driving offense, Mr. Salter, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. And now you can put your hand down. And Mr. Salter, do you understand everything we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
Do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
And what plea do you wish to enter, sir? Guilty or no contest?
No contest.
All right, I accept your plea and find that it is freely and voluntarily given. As to the misdemeanor charge for driving with a suspended license, your sentence will be an adjudication, time served. Now, as to the felony offense, the possession, I will reinstitute the standard bond in that case, which is $1,000. Is there anything else I need to be advised of?
No, Judge.
All right. So the bond will be set at $1,000 in that case. Okay? Thank you. All right. Thank you, ladies. Good luck. Okay. All right. I do have a case that was reset from the morning docket for this afternoon, and that is Michael Mack. Do you have him present at Maine, Mr. Romero?
Yes, Judge. Come on up, Mr. Mack. Mr. Mack? He's approaching, Judge.
And I did have an argument
I
as to
remember.
one of the counts.
I remember. All right. Good afternoon, Mr. Mack. Mr. Mack, you're before the court this afternoon on 3 charges. Count 1 is for robbery without a firearm or weapon. 2 is for second-degree petty theft, third or subsequent offense. 3 is for trespassing of an occupied structure or conveyance. And yes, Mr. Miller, I'll hear your argument now.
Judge, as to count 1, he's being charged with robbery, no firearm or weapon. This reads more like a resisting a merchant charge. And as far as I know, even in the attempt to recover their property or to detain someone, I don't think the merchant is permitted to lay hands on someone. And in this case, it appears that that's exactly what happened. So I think a more appropriate charge would be resisting a merchant, and I would ask the court to find probable cause for that.
Your Honor, the case law is very clear on this. A robbery is committed if in the course of the robbery, the defendant in a strong-arm robbery commits an act of violence or threat against the victim. He was still in possession of the property. He was still in the course of committing the robbery. Secondly, absolutely a loss prevention officer is permitted to detain someone that's committing a theft at the store they're working in. And I don't know how that would really go towards probable cause or not. One moment, Your Honor, I'm pulling the statute. An act shall be deemed in the course of committing the robbery if it occurs in an attempt to commit robbery or in flight after the attempt or commission.
Judge, we can't hear.
And actually deemed in the course of the taking, if it occurs either prior to, contemporaneous with, or subsequent to the taking of the property, and if it is in the act of taking constitute a continuous series or acts of events. So the fact that he already took the property is really irrelevant. Was it continuous? Considering he still had the property on him, I would argue it is a continuous series of events.
And Judge, I would just, again, what I'm arguing here is I don't think that a loss prevention officer has the right to lay hands on even someone who is stealing from them. And so this becomes self-defense. And so I think it changes from being a strong arm robbery to being a resisting a merchant, which again, I think is the more appropriate charge.
So it
I-
doesn't, I'm sorry, I was just gonna say, it doesn't say anywhere that he put his hands on him. It just says attempting to detain.
Yes, I'm just going to read the language directly from the probable cause affidavit. The paragraph that's at issue to what we're talking about right now says, the defendant passed all points of sale, making no attempt to pay for the merchandise, and exited the store. While attempting to detain and recover the merchandise, the defendant bladed his body in a fighting stance, then swung with a closed fist at the LP face, which was deflected by LP right wrist, excuse me. In other words, it doesn't appear to me that, or there's nothing that's stated specifically within the probable cause affidavit that the loss prevention officer laid hands on the defendant as to what you're saying, Mr. Miller, but I understand what you're saying.
Yes, ma'am, thank you.
For the purposes of today's hearing, I think that we have enough for me to make a probable cause finding. So I am going to find probable cause with regards to counts 1 through 3, and I will hear the parties' recommendations at this time.
Your Honor, I'm going to be requesting a $5,000 bond on count 1. Mr. Mack has a lengthy history of theft-related offenses. He has 2019 out of Broward, resisting without violence and theft. Out of Broward, grand theft, battery, resisting without violence. A little under 77 and a half months in Florida State Prison. He was released May 10th, 2018. Felony theft, 2012, 5-year state prison. Grand theft, uttering a forged instrument, 2012, just under 78 months state prison. Theft, 2012. Loitering and prowling, 2012. 1990, under the name of David Scott. Armed kidnapping, 2 counts. Armed burglary of a structure, robbery with a firearm or deadly weapon, 10 years in state prison. Nothing further.
Mr. Romero?
Judge, I understand the court having found probable cause, but certainly you can take into account for mitigation purposes what ultimately could happen with this case. I've seen certainly with this similar fact pattern that the state has chosen to go ahead and file it, as my colleague said, resisting with a merchant. Having said that, Judge, he's 54 years old. He's been here his whole entire life. He's working. He works at Common Soon Masonry, where he's been there for now about 3 years, Judge. My understanding, he is living in Pompano Beach with his father. He's going to be actually reaching out to his father to help post his monetary bond. My understanding is he's elderly. He's on Social Security on a fixed income. I'm asking the court to consider setting a $1,500 bond on count 1, along with the other bonds attached on 2 and 3. I believe my request is reasonable, Judge.
Your Honor, you should be aware, because it makes reference to the case number that he was trespassed from Sawgrass Mills. That was his 2019 theft and resisting without violence case. So when he was trespassing there, he was also stealing.
Bond on count 1 will be set at $2,500. I will leave the standard bonds in place on counts 2 and 3. While I do note that there is an existing trespass warning that's been put in effect for this location, I'm going to once again say that there is a no return order. Mr. Mack, that means that you are not to return to this location. Do you understand that, sir?
Yes, ma'am.
Thank you. Ashley Rivera,
Please.
Medical reset, Your Honor.
Brown? Oh,
medical
medical.
research. Okay. Thank you. Janice Flores,
Manja?
She's approaching Judge here at me.
thank you. Good afternoon, Ms. Flores.
How you doing?
I'm well. Ms. Flores, you're before the court on 4 charges. Count 1 is for possession with intent to sell, manufacture, deliver cocaine. 2, possession of cannabis, 20 grams or less. 3, attaching a registration or license plate not assigned to the vehicle. 4 is operating the vehicle with unsafe or improper equipment. That count is not for magistrate. I will hear from, I find probable cause and I'll hear from the parties.
Judge, and speaking of Ms. Flores, my understanding, she's 22 years old, been here her whole entire life. She's working, she works for a local trucking company, doing the dispatching, where she's been doing that for about 4 years. She lives in Hallandale Beach, with her aunt. More importantly, I believe she has a clean adult record. I'm gonna be asking if the court would consider releasing her on pretrial release.
And I would just advise the court that but for her denying using drugs, this would be a simple possession charge.
I'm fine with pretrial, Judge.
All right. I'm going to ROR her on count 1. Ms. Flores, you're going to be placed on standard pretrial supervision. You're going to be getting some information from your attorney there. You must report to pretrial supervision within 24 hours. If you fail to report to pretrial as I've instructed you, a warrant will be issued for your arrest. Do you understand that, ma'am?
All right.
Tiffany Smith.
Name, Judge?
Bonded, Judge?
All right, thank you. Amelia Ricano.
She's at North Broward, Your Honor.
Thank you. All right, good afternoon, Ms. Ricano. You're before the court this afternoon on 2 charges. Count 1 is for touch or strike battery. 2 is possession of cocaine. I find probable cause, and I will hear from the parties.
Judge, barring any extenuating circumstances, we're asking the court to keep the bonds as currently set. She does advise that she has a place to live that is separate and apart from the alleged victim in this case.
Okay,
I'm fine with that. Just ask that there be a no contact order.
all right. So I will leave the standard $1,000 bond in place. There will be a no victim contact order. Ms. Ricano, just so that you understand, the no contact order means that you are not to be in the same place at the same time as the alleged victim. It also means no phone calls, no text messages, no third-party contact, and no social media. Do you understand that?
Yes.
All right, thank you. Damian Miller.
Judge, Mr. Miller's at Paul Ryan. However, he has gone back to his cell. I'm prepared
Okay.
to waive his presence for purposes of this hearing.
All right, this is an add charge. Okay, all right, I do find probable cause. Do the parties wish to be heard on the additional charge?
This is the least of his problems, Judge.
All right, I'll leave the standard bond in place.
Thank you.
Thank you. Nicholas Dortch,
Conti?
thank you. All right, good afternoon, Mr. Dortch.
Good afternoon, Yana. How you doing?
I am well. Mr. Dortch, you are before the court this afternoon on an add charge. This is a charge for first-degree petty theft. I find probable cause, and I will hear from the parties if they wish to be heard.
Judge, I discussed this with Mr. George earlier. We're fine with the bond as currently set.
All right, anything from the state?
No, Judge.
All right, then the $100 bond will remain in place on this count. Okay, thank you, Mr. Dorch.
Thank you.
Cesar Gomez Bamaca.
Bonded, Judge?
All right, thank you. Jaroslaw Mikowski.
Maine?
Thank you. Good afternoon, Mr. Mikowski.
Good afternoon.
Mr. Mikowski, you're before the court on 3 charges. Count 1 is for DUI, alcohol or drugs, first offense. 2 is for improper stop. 3 is for disobeying or avoiding a traffic device. Counts 2 and 3 are not for magistrate. I find probable cause, and I will hear from the parties.
Judge, and speaking of Mr. Mikowski, my understanding is he has a clean record. He's 51 years old, been living in our community now over almost 20 years. He rents locally an apartment here in Fort Lauderdale with his roommate, where he's been there at that place for about 6 months. He works here in construction. Judge, if the state can verify he has no prior contact with the criminal justice system, considering this is a non-violent offense, and there is a presumption to be released on non-monetary conditions, I'm asking for the court for consider releasing Mr. Mikowski straight ROR on this case.
Okay.
Your Honor, I've seen a history. I'd be requesting pretrial with no alcohol or intoxicants random testing.
Judge, in this situation, I'm going to be asking if the court would consider a straight ROR. Basically, he is presumed innocent, imposing pretrial with those sort of conditions. As you know, there's a fee attached to it. There's going to be then monetary constraints.
I understand.
However, that's why I'm asking in this case, in his circumstance, he has no priors. It's not a DUI with property damage, and it's not a DUI with a certain breath level. That's why I believe it's reasonable for me to ask for a straight ROR.
All right, based on the circumstances, I would not normally ROR someone with a DUI case, but I do know that he has no priors and that there was no property damage as a result of the alleged incident, so I will grant the ROR today. Mr. Mikowski, a couple things that you need to understand. Though you're going to be released today, that does not mean that that's the end of this case, which means that it will be your responsibility to keep in contact with your attorneys and the clerk's office so that you know about any future court dates that you have to be present for. Do you understand that?
Okay.
All right.
Understand.
Thank you.
And this is the instructions where she just said this is our phone number to the PD's office. Call
Mike,
us and
please.
find out, make a, oh, sorry.
James Rayner.
Maine Jail, Your Honor.
Okay.
He's approaching, Judge, I'm sorry.
That's all right. Okay. All right. Good afternoon, Mr. Rayner.
How you doing, Your Honor?
I am well. Mr. Rayner, you are before the court this afternoon on a charge for disorderly conduct. I find probable cause, and I'll hear from the parties if they wish to be heard.
Judge, Mr. Rayner wishes to resolve this matter. We wanted to see if the state had a plea offer.
Mr. Rayner was placed on pretrial supervision on the 27th of January for grand theft case 19-1615
Pretrial is telling me he was placed on pretrial supervision on January 27th for a grand theft charge, and they're requesting that his pretrial services be revoked.
Judge, considering that the new law offense is it's a misdemeanor, nothing related to anything involving moral turpitude, I'd ask the court not to take any action on the case. He's out on pretrial, and I'd ask you to leave the standard bond in place.
I understand your argument, Mr. Romero, but a condition of his pretrial services are that he get no new arrests, and unfortunately that is what's happened here. So I'm going to grant pretrial's request. I will take that in consideration into setting a bond in both cases. So I will hear recommendations from the parties as to bond on both the grand theft case as well as the disorderly conduct case that is before me today.
Judge, on the grand theft that he's out on, I'm going to be requesting a $1,000 bond.
That's fine.
All right, the bond in the disorderly conduct case will be set at $1,000. I'm sorry?
Sorry, you're setting the.
Excuse me, excuse me, the grand theft case. Thank you for
Thank you,
catching
Judge.
that. All right, the grand theft case bond is set at $1,000, and do we have recommendations as to the new case?
Just asking that, yeah, I'm just asking.
I think
that you let
Mr.
it play.
Romero requested the bond is set.
All right, the standard bond will remain in place on the new case. $25. Thank you. Jose Ruiz Melendez.
I believe North Broward?
Okay. We'll try it. Jose Ruiz Melendez.
They're saying he bonded, Judge. I
Oh, he bonded?
apologize.
All right, that's all right. Okay. Floyd Madison.
Mr.
Maine.
Madison is here at Maine, Judge. Come on up, Mr. Madison.
Right. All right, Mr. Madison, you're before the court this afternoon on 3 ad charges. Count 3 is for failing to comply with registration law. Count 4 is a sex offender violation, failure to report name or residence change. 5 is an additional sex offender violation, failing to report vacating a permanent residence. I find probable cause for these charges, and I will hear from the parties.
Your Honor, I'm requesting a bond be set at $5,000 per count. Mr. Madison is being held no bond for attempted felony murder.
Okay. Anything to add,
Judge,
Mr. Romero?
considering his no bond hold, Judge, I know he's represented by the Public Defender's Office. Nothing to add at this time.
Okay. All right, in light of that, the bond on each of these charges will be set at $5,000. Thank you. 5,000 each. Yes. Okay. Juan Gaviria.
Judge, Mr. Gaviria is at Conti. I spoke to him and I'm going to waive his presence for purposes of this hearing. We're going to stand mute with regard to the bond amount.
All right, so this is an ad charge for burglary. I find probable cause. And what is the state recommending?
Your Honor, requesting a $2,000 bond. He has felony no bond holds, juvenile no bond holds.
All right. In light of that, there will be a $2,000 bond in this case. Thank you, gentlemen. Robert Jackson.
Maine?
He's approaching Judge Maine.
Thank you. Good afternoon, Mr. Jackson. You're before the court on 2 ad charges. Count 5 is for burglary of an unoccupied structure, unarmed. 6 is for second-degree petty theft, third or subsequent offense. I'll hear from the parties.
Judge, Mr. Jackson just wants to know, when was the alleged date of incident on the burglary offense?
This is from January 25th, 2020, I believe. Is that correct, Mr. Linder?
That is correct, Your Honor.
Yes.
He's got a no bond hold on a VOP Grand Theft Auto. Because this was, because this was a business, I'd be requesting a $2,500 bond.
Last question on behalf of Mr. Jackson. He wanted to know where was the location?
Walgreens. Walgreens. Like our friend Mr. James, he's been accused of jumping the counter at Walgreens and stealing multiple packets of Newport cigarettes.
Yes, Judge.
Okay. Do you have anything you want to add, Mr. Romero?
No, he's being held no bond, Judge.
All right. In light of that, the bond on count 5 will be set at $2,500, and I'll leave the standard bond in place on count 6. For the record, I do find probable cause if I didn't say that already. Thank you. Michael Lane.
He's approaching Judge here at Maine.
Thank you. Good afternoon, Mr. Lane.
How you doing, Samantha?
I'm well. Mr. Lane, you're before the court this afternoon on 4 charges. Counts 1, 2, and 3 are each a separate charge. for attempted murder in the first degree. Count 4 is a misdemeanor capias related to a charge for battery. I find probable cause, and I will hear from the parties at this time.
Your Honor, the state would be seeking a finding of proof evident or presumption great for first appearance purposes, and that Mr. Lane be held no bond on these 3 counts. He was identified by the adult victim who recognized him, knows him. Other physical evidence corroborates the version of events. Casings were found, projectiles were found in the vehicle. Both the victim and his son were shot as a result of Mr. Lane's actions. Both went to the hospital, Your Honor. The victim identified Mr. Lane via photo array, which really just further enforces the identification, as he advised law enforcement that he already recognized him before even having to take a photo array. One moment. Your Honor, I would also note they located the casings. There were also multiple bullet holes in the victim's vehicle.
Mr. Miller?
Judge, other than objecting to the finding of proof evident, presumption great, based on the hearsay testimony of an affidavit, I have nothing further to add.
Thank you. All right. I do also want to note for the record, because I didn't mention this before, the misdemeanor capias for battery has a no bond set on it by the division judge right now as well. With regard to counts 1, 2, and 3, I have reviewed the probable cause affidavit. At this time, the court is going to make a preliminary finding of proof evident presumption great in order that Mr. Lane be held no bond on counts 1, 2, and 3. That is without prejudice for him to have the appropriate hearing before his division judge to further address that matter. Thank you.
Your Honor?
Yes.
In abundance of caution, I'd ask for no victim contact.
All right. I will impose that order. Mr. Lane, there will be an order of no victim contact in this case. Whether you know the alleged victims or not, I need you to understand that no victim contact means no being in the same place. It also means no phone calls, no text messages, no third-party contact, no social media. Do you understand that, sir?
Yes, ma'am.
Thank you. Martin Kohler.
He's here at main, Judge.
Thank
And Judge, we
you.
have an argument as to count 1.
All right. Good afternoon, Mr. Kohler.
Good afternoon, Your Honor.
You're before the court this afternoon on 2 charges. Count 1 is for aggravated battery on a person 65 years of age or older. 2 is a misdemeanor capias related to a petty theft charge. And Mr. Miller, I'll hear from you at this time.
Judge, I think we're missing the element of intent. Mr. Kohler, according to the probable cause affidavit, alleges that he accidentally closed the door on his stepmother's arm. I don't see, and I may just have missed it, but I don't see where she claims he did it on purpose. And there is testimony, again, in the probable cause affidavit where 2 other witnesses say that it never happened, or they say that she may have injured herself and forgotten about it, or forgotten what the argument was about. And so I don't think we have reached the element of intent, and that's required even in a domestic situation. And so I would argue there is no probable cause to hold him over on an aggravated battery at this time. That's all I got.
Thank you. Mr. Linder?
All right, based on her statement and the way the victim describes it, it certainly can be argued that there was intent. She was standing in the doorway at the time of the act. He walked deliberately to her where she was standing at that time. At that time, it also closed the door on her arm. There's nothing to indicate that she was on the other side of the door. She was standing in the doorway. There's nothing described here in her statement to indicate that it was accidental. I understand that she advised that her husband and stepson believes that she injured herself on purpose, and if anything, I think that lends her credibility because, frankly, it would have been under, it would have been better for her case to just not even mention that at all. But she's being honest. She's mentioning what other people think, and they're entitled to her opinion. But based on the report, it would indicate from what she advised law enforcement, there's certainly evidence that it was an intentional act.
And Judge, in the interest of full disclosure, I've read the next paragraph, I've read it again, and it does say that she does believe that he did it with intent.
Yes. All right, I do note there are obviously conflicting statements between the parties in the probable cause affidavit. For the purposes of today's hearing, I do have what I need to make a finding of probable cause. Obviously, I'll take everything into consideration in setting a bond in this matter. But for the record, I do find probable cause with regard to both counts that are before me. And I will hear the parties' recommendations at this time.
Requesting a, excuse me, Your Honor, $2,000 bond, no victim contact.
Judge, that's reasonable. Yeah.
All right. Then the bond on count 1 will be set at $2,000. I'm going to leave the bond in place on count 2. There will be an order of no victim contact. Mr. Kohler, so that you understand, the no victim contact order means no being in the same place at the same time. That also means no phone calls, no text messages, no third-party contact, no social media. Do you understand that, sir?
Yes, Your Honor.
All right, thank you very much.
Judge, before we turn the page here, he does have
Yes.
count 2. Mr. Romero, would you ask Mr. Kohler if he wants to try to resolve that?
Okay.
He does, what? Oh, one moment, Judge. Not at this time, Judge.
Thank
Okay.
you, Your Honor.
All right, thank you, gentlemen. Next will be D'Angelo Brim.
First of all,
Good afternoon, Mr. Brim.
Yes, how you doing?
I am well. Mr. Brim, you are before the court this afternoon on 8 charges. Count 1 is for driving while license is suspended, habitual. 2, operating without a valid driver's license. 3 is for disobeying or avoiding a red light. That count is not for magistrate. Counts 4, 5, 6, 7, and 8 are each a misdemeanor capias. And those relate to charges for DUI, property damage or injury, driving under the influence, and leaving the scene of an accident. I do find probable cause for these charges, and I will hear from the parties at this time, if they wish to be heard.
Judge, can we check to see if his bond's been posted?
Yes, I'll check with confinement. Okay. It's not showing that it's been posted yet.
It will be, Judge.
Okay, all right, I'll leave the standard bonds in place. Terrence Mitchell.
Mr. Mitchell, come on up, please.
Good afternoon, Mr. Mitchell.
Good afternoon.
Mr. Mitchell, you're before the court this afternoon on 1 charge for driving while license suspended, 3rd or subsequent offense. I find probable cause, and I will hear from the parties.
Judge, nothing to add from the defense.
All right, anything from the state?
no, Judge.
All right, the standard bond will remain in place at this time. Thank you. Frank Kaltenecker.
He's approaching, Judge. Come on up, sir.
Good afternoon, sir.
Good afternoon.
You're before the court on 2 charges. Count 1 is for possession of methamphetamine. 2 is for driving while license suspended, first offense. I find probable cause, and I'll hear from the parties.
Judge, we're gonna be requesting, if the court will consider releasing him on pretrial release. I'll see if the state has an objection before I proceed.
It's all traffic, right? Okay, next. Now, next. Well, this is out of state stuff. Go all the way down to the most recent. Okay. That's fine, Your Honor, with random testing.
All right,
No, the judge can explain.
Mr. Kaltenecker, I'm going to ROR you on count 1. You'll be placed on pretrial supervision. You will also be subjected to random testing. That means no alcohol, no intoxicants. Do you understand that, sir?
Yes.
All right, you're going to be getting some information from Mr. Romero. You must report to pretrial supervision within 24 hours. If you fail to report to them as I've instructed you, a warrant will be issued for your arrest. Do you understand that, sir?
Yes, ma'am.
All right, thank you very much.
There's the location of pretrial. Report that tomorrow morning. Good luck, sir.
Okay.
Mr.
Next will be
Vasquez?
Kevin Vasquez.
He's approaching, Judge.
Thank
We
you.
have an argument regarding count 1, Your Honor.
All right. All right, good afternoon, Mr. Vasquez.
Good afternoon, Your Honor.
You're before the court this afternoon on 6 charges. Count 1 is for possession with intent to sell, manufacture, or deliver cannabis within 1,000 feet of a school, convenience business, or park. Count 2 is for possession of THC. 3, possession or use of drug paraphernalia. 4, driving while license suspended, second offense. 5 is no tag light, and 6 is a tinting violation. Counts 5 and 6 are not for magistrate. And Mr. Miller, I will hear your argument as to count 1.
Judge,
Can we first check to see if his bond's been posted?
Okay. Mr. Vasquez, Kevin Vasquez. Well, that's what I was checking for. All right, his bond has been posted.
Thank you.
Thank you. I'm
Get on
sure
the
you
same page
did.
as Romero. Can't even blame me.
Thank you. Mark Tyndall.
For North Broward?
Judge, he refused, apparently.
All right.
Ask the court to make a probable cause determination. If Mr. Miller wants him brought back for bond purposes, that's fine.
Okay, I think he's been reset once already, right?
Yes.
All right.
Without objection, Your Honor.
Okay, so then I will make a probable cause finding in absentia as to both counts, and we can have him reset as to bond. Michael McMillan.
Medical reset.
All right. And let's go over to our hearing docket now. On page 2 of the misdemeanor docket, I have Charles Johnson. Here for a third day motion.
Conti?
Thank you. Good afternoon, Mr. Johnson.
Yes, ma'am. How you doing?
I am well. All right, so is Mr. Johnson here on a 30-day?
No,
What is this?
It's a second look. He was arrested on a January 15th on a felony theft that was downfiled to a misdemeanor theft.
All right. I think his bond is $100. Is that correct?
Yes, that is correct. He also has a pending grand theft that he was ROR'd on. It has since been filed. The reason he's been in, Your Honor, for 23 days
Yes.
is because the day after he was ROR'd, he was arrested for this new theft. And, Your Honor, was not inclined to, well, obviously he couldn't resolve it at that time. It was a felony and you were not inclined to modify.
Right.
If he wishes to resolve the case now that he's done 23 days,
Yes.
the offer from the state would be adjudication time served. But I want Mr. Johnson to understand, and I'm not saying he's gonna do anything about him getting released, but if he ends up before the court on a theft-related matter, there won't be a time served offer from the state.
And it'll most likely be a felony anyway.
Well, I'm saying if they charge him with a misdemeanor, just obviously if it's a felony, I can't make an offer, but.
Right.
Mr. Johnson, did you hear what Mr. Linder has just said?
Kinda,
Okay, I'm gonna repeat it for you.
okay,
What he's telling me is that in your petty theft case that's before me today, if you want to resolve the matter, the offer from the state is an adjudication time served. However, he wants to advise you that if you do pick up any new charges related to something similar in the future, their future offer will not necessarily be a time served offer. Do you understand that?
yes, ma'am.
All right. Do you wish to accept the adjudication time served offer that they're offering you now?
Yes, ma'am.
Okay.
Judge, may I just
Yes, go ahead.
Mr. Johnson, this is Mr. Miller from Bond Court. I just want to advise you that even if it's a misdemeanor, going forward, every time you pick up a theft charge, it's going to be charged as a felony.
Yes, sir.
Okay, this is your two chances are over with. Every time going forward, they're going to charge it as a felony, even if it's a pack of gum.
Yes, sir. I'm gonna try to straighten up, so,
All right.
to go the right route, so y'all shouldn't have to see me no more, so.
All right. Well, I'm glad to hear that, Mr. Johnson.
Yes, ma'am.
So let me just ask you a few questions and then we'll be done for the day, all right?
Yes, ma'am.
Will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. And now you can put your hand down. And Mr. Johnson, do you understand everything that we've discussed here today?
Yes, Your Honor.
All right. Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
Do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
And what plea do you wish to enter, guilty or no contest?
No contest?
All right, I accept your plea and find that it's freely and voluntarily given. So once again, your sentence in this matter will be an adjudication time served. Good luck
Thank
to
you,
you,
Your Honor.
Mr. Johnson.
Thank you.
All right. That's for, Mr. Linder, is that including, there's a second count for resisting on that, or is that
Yeah, it was to
for
include
the whole
all.
thing? Yeah, that's what I thought, it's for the whole thing. All right, so now we'll go to the felony docket. On page 2, Corey Johnson.
Is it Conti, Judge? This case was downfiled to a misdemeanor 20001155 MM10A.
All right. Good afternoon, Mr. Johnson.
Good afternoon, ma'am.
All right, so since it was downfiled to a misdemeanor, what are his current bond amounts?
It's 20,000 plus GPS, Your Honor, but frankly, this is a domestic violence case.
Okay,
I'd ask the court to take no action on bond so that if the defense wants to seek a modification, the victim can get proper notice if she or he wishes to address the court.
that's fine. I always just like to check
Of
to
course.
see what it is so that they're advised of that, okay?
Absolutely.
All right, so Mr. Johnson, what I've been told is that the charges have been filed, but it's been downfiled to a misdemeanor. Your bond amounts are the same right now, and so if your attorney wishes to seek a modification as to that, they can file a motion and address it with your division judge. So the next step will be for you to go before your division judge for an arraignment hearing on the charges that were filed. All right?
I'm just checking to
Good
see
luck
if
to
we
you,
have a
sir.
date yet, Your Honor.
Oh, you want to see? Yes, hold on one second, Deputy. I just want to see if he has an arraignment date set yet.
He Yes, the,
Monday.
yeah, 10th.
He has
So
on
you-
Monday?
Yeah,
9
you'll
a.m.
see
on
Judge
the 10th.
McHugh on Monday.
All right,
Hey,
so,
Your Honor,
yes, Mr. Johnson.
is there any way I can get pretrial release or ROR?
Oh,
I, Mr. Johnson, I can't do that for you today, but you're going to be seeing your division judge on Monday, so you can discuss it with your attorney and your judge at that time, okay? Good luck to you.
Okay, thank you.
You're welcome.
Judge, just
Yes.
to make sure, can we be appointed on the new case as well?
Yes, I
Okay,
will
I'll
sign that
prepare an
over.
order.
That's fine. All right. On page 3 of the felony docket, Theodore Fullard.
Maine? I'm sorry.
Oh, is it North Broward?
He's at North Broward, Judge.
Okay. Good afternoon, Mr. Fullard.
Yes, ma'am.
All right, what's going on in Mr. Fullard's case?
Judge, he's been in custody for 5 days on the 5 burglary charges, $1,500 each. This is the one that we had to have perfected the second
Yes.
day.
Yes.
Your Honor, I think some cause for concern in this case was the allegation that he was targeting 5 vehicles all at one time, all in one vicinity. Additionally, his history, possession of cocaine, 2012, VOP, 15-month state prison. Loitering and prowling, 2012. Burglary of a conveyance, 2012, 15-month state prison. Loitering and prowling, and assault on a law enforcement officer, 2012. Burglary of a conveyance, 2011, VOP, 15-month state prison. Burglary of a conveyance, 2010, VOP, a year and a day state prison as a habitual offender. Loitering and prowling, 09. Battery on a law enforcement officer, 09. 06, 2 counts of burglary conveyance, battery on a law enforcement officer, resisting with violence and theft. He was qualified as a habitual offender in that case. Loitering and prowling, 08. Assault, battery, resisting without violence, 05. Loitering and prowling, 05. Loitering and prowling, 04. Loitering and prowling, 04. Loitering and prowling, 03. Burglary of a conveyance, 02, a year and a day, state prison. Burglary conveyance, 01. And as I advised the court when at his first appearance, there are other priors that I've left out. The ones I've brought up are clearly the ones that are most related to the instant offenses he stands before the court on.
I understand. All right, at this time, I'm going to deny the request and leave the bond in place as has been set. All right, thank you, Mr. Fullard. Good luck to you. Next will be Sheldon Gray.
Mr. Gray's here.
Hey, jail, Your Honor.
Thank you.
Mr. J has been,
All
Hello.
right,
Mr. Gray has been in custody
Okay.
for 4 days on a grand theft, and the bond is $1,000.
I believe one of the issues the court had, not even taking into consideration the history, there was an arrest January 11th for petty theft. There was ROR, and now Ms. Gray's back before the court on a grand theft. Additional priors, 2018, attempted robbery with a firearm or deadly weapon and aggravated battery, 16-month state prison. Grand theft auto, 2016, VOP, 16-month state prison. Dealing in stolen property, false ownership info on a pawn item, 2016 with a VOP, 16-month state prison. 2 separate possessions of PVP, one in 2016, one in 2015, VOP, 16-month state prison. Frankly, Your Honor, I think Ms. Gray's very fortunate that Your Honor didn't not only increase the bond in this case, but it certainly would have been within your discretion to issue a no bond hold on the violation of release conditions on the pending theft.
all right, at this time, Mr. Romero, I'm sorry, did you want to add something?
Judge, I understand Mr. Gray has a record, but he's not going to be able to afford it. The good thing, I think I mentioned this before, he went to an interview at Checkers, he got the job, so he has a job waiting on him. He's living with his aunt, but other than that, Judge, no one's going to be able to pay his bond, so that's why he's asking to be released on pretrial.
Okay. At this time, based on the information that's been given to me, I'm going to deny the request and I'm going to leave the bond in place as it is. All right, good luck, Ms. Gray. On page 4, Wilfredi Ramos Gonzalez.
Bonded.
All right, thank you. Also on page 4, Lionel Derrico.
Here remain.
Thank you.
Judge, Mr. Derrico has been in custody for 4 days, 3 charges, grand theft, driving on a suspended license, and possession of cannabis. His bonds total $1,750.
Okay.
Patrice?
And Judge,
You
he's
have
not
notes
gonna
when
be
he
able
got
to
out of
afford
state
to post a
prison?
monetary bond. He's on disability, he lives in Pompano Beach with his grandmother, who is also on disability. He has a record, but my understanding, he's been clean since he got out for about 1.5 years now. So he's asking to be released on the pretrial.
Your Honor, I will accept Mr. Romero's representation that he got out of the prison 1.5 years ago. December 2018? September? Okay. That would have been for a carjacking where he violated probation and was sentenced to 5 years state prison as a habitual offender. Part of the reason he violated probation was on a criminal mischief in 2016. Additional priors include assault on a law enforcement officer, 09, escape, 04, resisting without violence, 06. Checking one other thing. I'm sorry, I'm just reading over the report again, Your Honor. I have nothing additional, Your Honor.
All right, at this time, I'm going to deny the request and leave the bond in place. Thank you. Good luck, Mr. Derrico.
Hey, Judge, before we close the book,
Yes.
I was wondering if I could ask for one matter off docket.
All right, what's that?
I have a bond issue regarding one of my clients, Harold McKinney Ely. He's out at North Broward. He just needs access to his property so that he can self-bond. I can advise the court that the case was filed about 2.5 hours ago.
Okay, all right.
And it's 200000616 CF10A. Charges felony, criminal mischief, and touch or strike battery. The bonds are set at $1,000 total.
All right, I'll sign the property order on that.
Thank you, Judge. May I approach?
You're just
Yes.
asking for him to have access to his...
That's it.
Yeah, it's just for property. All right, thank you, everyone. I'll see you all back here tomorrow morning.